The Louisiana Supreme Court recently ruled in favor of a New Orleans detective who pulled over a motorist he suspected was engaged in criminal activity. Ultimately, there was illegal activity taking place, but the traffic stop and resulting search of the vehicle was done without probable cause. KLFY TV 10 Eyewitness News reporter Doug McDermott joins us now in the studio with more. Doug?
Thanks, Blue. The ruling came down last week in the Louisiana Supreme Court in the case Louisiana versus Curtin. Basically, this is what happened. A New Orleans police detective, Rockefort, pulled over 27-year-old Crystal Strait, who he believed was conducting a drug deal. His suspicion served him right. Strait had heroin on her. But the issue with this is that Rockefort did not use probable cause to pull over Strait. Rockefort used in what the Supreme Court called his experience as a narcotics investigator to determine she was definitely breaking the law. A judge in the Orleans Parish Criminal District Court had ruled the search was unlawful because no probable cause was used. Now, this was appealed by the prosecution, and the question is now, does this ruling open the door for police to pull over whoever they want to if they feel that person is breaking the law? Local criminal defense attorney Kirk Piccioni believes it does.
A person's actions could be interpreted either way. You know, they might be criminal, might not. I think you're going to see a lot more investigative stops, a lot more searches, and a lot more arrests.
How are the police responding to this new ruling, and will it change their protocol? That's coming up tonight at 6. Reporting live in the studio for KLFY TV 10 Eyewitness News, I'm Doug McDermott.
At 5, we told you about a new Louisiana Supreme Court ruling that allows police opinion to serve as probable cause.
In other words, if lawmen suspect criminal activity, then they can use that as probable cause to act. The question now is, what does this mean for law enforcement? And equally important, how will it impact you, the general public? KLFY TV 10 Eyewitness News reporter Doug McDermott has been taking a look at the situation and now joins us with more on the ruling. Doug.
Yeah, thanks, Chuck. When police pull someone over, there has to be probable cause, such as a traffic violation. But this new ruling now grays the definition of it.
And I don't think the Supreme Court has opened any bigger door than that was there before. They reaffirmed what the New Orleans police officer did was correct.
Police say this ruling changes nothing, but local criminal defense attorney Kirk Piccioni feels differently.
I would imagine that this is going to result in more searches, more arrests, more investigatory stops.
Piccioni says that this allows an opinion or a hunch of an officer the right to search a vehicle and apply it in court.
If a police officer offers his opinion that something looks like criminal activity, there's no way to test that.
Captain Kip Judice with the Lafayette Parish Sheriff's Department says that their department analyzes deputies' actions.
Police officer must be able to articulate probable cause to the finder of fact at some point in the future, prosecutor and or the judge.
In this case, the justices stated the New Orleans police detective, based on his experience, was justified in pulling over the suspect without probable cause. Well, for Piccioni, he feels this could be the start of a slippery slope.
We place a great deal of value on an individual's independence and privacy and right to be left alone. And we're going to lose that.
Now, some may look at this argument and say, well, if an officer stops someone and finds something illegal, then job well done. But on the flip side, others would argue in the event nothing is found, then an innocent person is subjected to what opponents define as an unlawful search. Reporting live in the studio for KLFY TV 10 Eyewitness News, I'm Doug McDermott.